This is okay. I'm on. Have you? I can go ahead. Good morning, everyone. Welcome to today's class. Today we'll be discussing business law. I'm your facilitator for today, Umi Ohana, and we'll be talking about registration of business and compliance requirements. So that's the module for today. Uh, Module 6 is registry business law, registration of business and compliance requirements. So, what are participants expected to know? So, what are the things I expect you to know by the time I'm done taking this module? So, first of all, participants to have a basic understanding of the nature of the legal system in Nigeria and to understand the legal regime and regulatory agencies regulating businesses in Nigeria, and for participants to know the types of business organizations and steps in the formation and registration of businesses in Nigeria. This uh, module, this is what I expect you participants that are listed on the slide 3, 4. So these are the things I expect you to know. We'll be tackling and either one of the objectives until we've gotten to the last objectives of what we want participants to learn today. So, Nigerian legal system. Today you get to have an idea of when they say Nigerian legal system, what are we talking about? Then we'll look at some relevant government agencies regulating businesses in Nigeria. Then we look at the types of business organizations and legal implication of the various types of business organizations. And then we'll look at registration. So right now, we're going to look at what Nigerian legal system is. And when we talk of the Nigerian legal system, we're basically talking of in this sense, consists of the totality of laws or, or legal rules and legal machineries which are obtained within Nigeria. I said it consists of legal rules, legal laws, and legal machineries which are contained within Nigeria as a sovereign country. So when we talk of the Nigerian legal system, anything that has to do with, basically a country is run on laws and and is on laws and there are mechanisms, authorities to ensure that the various arm of government we have is also part of our legal system. So it's the ground norm. It is the source. It's our constitution that created the executive arm of government, the legislative arm of government, the judiciary arm of government. The legislative arm of government is there to make laws. The executive arm of government is there to implement such laws. The judiciary is there to interpret such laws made by the legislature. But these duties are not exclusive to each arm of government, because there are situations where you see the executive initiating bills and they are submitting it to the National Assembly. There are situations where the judiciary, by virtue of interpretation, is making laws. So we'll look at all these things. But basically, when we talk of the Nigerian legal system, when we talk of all the laws that are obtained in Nigeria, from the Companies and Allied Matters Act, the Universities Act, University of Abuja Act, University of Benue Act, the Nigerian Maritime Act, the Stamp Duty Act, the the Stamp Duty Act, the all these, the Criminal Code. Sorry for the break in transmissions due to network problem. So as I was saying, we have the police, we have the immigration, we have the police, we have the immigration, we have different agencies of government whose duty are there to implement the law. They are there to implement those laws that have been enacted either by the National Assembly or those ones that have been interpreted by court to mean a different thing. So, having looked at what the Nigerian legal system is, or having discussed what the Nigerian legal system is, let's look at the meaning of law. What is law? So, generally, there is no one acceptable definition of law. Law means different things to different people. But for the purpose of this module and to the lawyer and law profession, is more interested in the narrow and guarded meaning of law as a rule of human conduct. What is rule of human conduct tacitly or formally accepted by a people as binding and backed up by some mechanism for the sustenance of its binding nature. So let's break down this definition. First of all, for something to be considered a law, it must be formally accepted by the people. You cannot, when you come and impose something on people, such cannot be regarded as say, uh, this is the law now in country. They will just pass a decree and say this is the law. But when we are in a democracy, people and and it has a binding nature, it must be backed up by some mechanism. Because even if the laws are made without mechanisms for the sustenance of its binding nature, it will not work. Because that's why we have different agencies of government, different ministries of government are put in place for the purpose of ensuring that these laws are functioning. They just don't exist in vacuum. People are indeed abiding by the provisions of this law. So that's why we said it must have some mechanism for the sustenance of its binding nature. For instance, let's the Constitution of Nigeria. We have the preamble where it states, "We, the people of Nigeria, that we accept that this." So if you read the Constitution, you will see where we formally in code, where we all formally agreed and accepted the Constitution to be the ground norm of the country, and they are backed up, and it's backed up uh, by some form of mechanism. What are the mechanisms? The executive, the judiciary, the legislation, the legislative arms of government are there for the purpose of ensuring that these laws are put in place. Then we have sources of Nigerian laws. So when when we're talking about sources of Nigerian laws, basically we are just looking at how the laws in Nigeria came about. Because the laws did not just fall from the sky. First of all, we have common law and doctrine of equity. They are together. These two are referred to as the English receipt law. Back then, while the British were colonizing Nigeria, they, they brought their own laws, which are the common law, which is the common law and doctrine of equity, which are the common law and doctrine of equity. So these laws were received into Nigeria and they form part of our law presently. So let's look at the common law. When we say common law are just rules and regulations that were developed based on the customs and traditions of the people of England back then in the reign that were administered by the common law courts. So this common law is more like the customs and traditions of the people of England that evolved into a written code and formally accepted by the people to be enforceable among them through the common law courts back then in England. So let's do a little bit of history of how this common law came about. So what happened was in England back then, before the Norman conquest, and I guess when King Henry II was king in England, what happens is that he sends out itinerant justices. When I say itinerant justices, I mean justices that move around. They move around for the purpose of administering justice in the name of the crown. So they will go from one location to another, they will list 18 matters. Then after they've had matters in different settings, they will come back to the capital, the crown, which I guess is London, and they will discuss the various customs they came across. For instance, now in one community, one of the justices experienced a custom that is uh, that is good, and he feels it should be enforced in other settings, in other localities within in England. Then they will say, okay, I came across this law, this custom is good. Let's be applying it in all the settings. Okay, I came across this custom. So that's how common law evolved, and it was written. So as a result, they have what is called common law. But over time, common law became so strict. Rather than being concerned with administration of justice, common law now became more concerned with forms and procedure. That means common law, if they say for you to have a contract for sale of land, it must be in writing. It must be in writing. That is common law. So if you fail to put that contract for sale of land in writing, and you approach the common law courts for remedies, where the other party failed to allow you to take possession of that land, common law courts will not entertain your matter, even though you have a case. They will not issue a writ to you because they said such contracts must be in writing. And when you fail to put that contract in writing, it, common law will not even look at you. So such things was becoming much. So it made litigants to be aggrieved. So as a result, litigants began petitioning the crown. So they will petition the crown. So when they petition the crown, uh, it is the King's Council that will entertain such matters. And part of the King's Council, then there was a chancellor, and the chancellor was a priest. And based on his priestly background, he will decide some matters. So that's how the doctrine of equity evolved, because litigants were dissatisfied with what they are getting at common law courts. So they will petition the crown, and then the chancellor with his people will entertain the matter. So doctrine of equity is not fairness in the ordinary palace as we know it. Rather, doctrine of equity in this sense and for the purpose of this model is the law developed by the Court of Chancery. Remember, I told you that the Chancellor is part of the King's Council. So, doctrine of equity is a law developed by the Court of Chancery for the purpose of mitigating the harshness of common law. So, for instance, where I gave you an example of where I said a contract in under common law, if it says that contract for the sale of land must be in writing, it must be in writing. So when you fail to put it in writing, the common law courts will not entertain your matter. Then we go to the Court of Chancery when you petition the Crown, and it's the Court of Chancery, which is headed by the Chancellor, that will entertain your matter. They will look at it and say, no, okay, yes, there is a contract. The fact that you fail to put it in writing should not stop you from approaching the court. So that's how the doctrine of equity evolved to mitigate the harshness of common law. So this received English law comprising of common law, doctrine of equity, statute of general application. So these laws form part of our laws because there are some acts that if you check the Nigerian laws or you check the laws of federation, you see that we still have some acts that were applicable in England back then in 1960 something, and yet we've not still amended such acts. They are still applicable in Nigeria presently. So this common law and doctrine of equity, they form part of our law. That is why you hear he who comes to equity must come with clean hand. If you are coming to court to say, this my right is an equitable right and I'm coming to court for, you must approach the court with a clean hand that, okay, you are not tempted. And he who comes to equity must. So these are doctrines that are still applicable in the Nigerian law. So the next source of Nigerian law we're going to look at is the Nigerian legislation. As I said when we began discussing law, that the Nigerian legislation is there to make laws. So we have quite a number of laws that have been passed by the National Assembly and the various state house of assemblies. We have quite a number of laws. So when we look at these laws, for instance, recently the Companies and Allied Matters Act was passed into law, and I guess the Bank and Other Financial Institution Act of 2020. Is it the president just transmitted or it has been passed into law? So these are laws that are made by our legislation. The act establishing the Niger Delta Commission, the North East Development like our penal code, criminal code, and the rest, even though they are influenced by laws of one jurisdiction or the other, but still they have to be by our National Assembly for them to become laws in Nigeria. Then we have the customary law. When we talk of the customary law, we are talking of body of customs and traditions which regulate the various kinds of relationship between members of the community in a particular setting. So just like the common law in England, which I said was based on the custom and traditions of the people of England back then in the realm, so is our customary law. Our customary law are still applicable in Nigeria. So customs, that's why we have customary courts for the purpose of administering customs in Nigeria. For instance, now let me give you an example of a notorious custom in Nigeria that anywhere that custom is known to be notorious, and that custom is the Benin customary custom of inheritance. So that Benin customary law of inheritance, which allows the first son of the deceased to inherit his property, that is the particular house he's possessing at the time of his death, then that custom is notorious. So anytime it goes to the Supreme Court, any court, once it goes to any court, that customary custom is applicable because it's notorious. So there are customary laws that are still applicable in Nigeria. That's why we have the customary courts created for that purposes, for the purpose of administering our own local customs and traditions based on the custom and traditions of the people of that particular settings. For instance, we have the judges administering such courts are people who are versatile and well abreast with the custom and traditions of that particular settings. So let's look at judicial precedent and case law. Remember, I also said the judiciary is there to interpret the law. So in the course of interpretation, the judiciary also make laws. Let's say a section of the CAMA now, there is a problem with the section of CAMA. So parties will normally approach court. So what the court will interpret that section to be, if the literal reading of that section says is you put it in the car, then the court decides that no, you don't put it in the car, you put it in the boot. So that section now becomes you put it in the boot. And especially when it goes to the Supreme Court, and the Supreme Court decides that that particular section in KAMA is you put it in the boot. So that section now becomes the law. So anything that happens, and then anytime the courts come across that particular section 20 of KAMA, for instance, they will interpret it to mean you put it in the boot, not you put it in the car. So that is judicial precedent. And once it goes to the Supreme Court, and the Supreme Court decides a matter, which we will talk about subsequently when we are talking of hierarchy of Nigerian courts, which is the next topic we will discuss. You get to see that once the Supreme Court of Nigeria, which is the apex court of the land, decides on the particular issue, that issue becomes binding on lower courts in Nigeria. So that's why we said judicial precedent or case law. So that interpretation, for the example I use of section 20, when decided by the Supreme Court that is put it in a boot, it becomes the law in Nigeria. That is the law. Put it in a boot. Anytime it goes to any court and the facts are similar, the circumstances are similar, the court will interpret it that section it meant you should put it in the boot, not in the car. Then we have the international law. When we talk of international law, we're talking of convention, treaties, customs, and practices that regulates the relationship between various countries of the world. So we have some international laws that form part of our own laws. For instance, Chapter 4 of our we supported the United Nations Declaration on Human Rights and the African Charter on Human Rights. So these are things that influence how we make our law. So the international law plays a vital role in how Nigeria sources its laws. For instance, now for any international law to be applicable in Nigeria, it must be domesticated by the National Assembly. That is, the National Assembly must pass it into law. So Nigeria will domesticate it as its own, even though we are treated to such. So let's quickly look at the hierarchy of Nigerian courts. As I said earlier, the Supreme Court is the apex court of the land. Once the Supreme Court decides on an issue, it becomes final. That is why if you hear issues of election, it goes to the Supreme Court and they tell you the Supreme Court has decided that this is the winner. The PDP candidate is the winner, the APC candidate is the winner. It becomes final and it ends there. For instance, the Imo matter, where the PDP, it was PDP that was said to have won the election initially, went to the tribunal, went to the Court of Appeal. But when it went to Supreme Court, the Supreme Court said, no, it's not PDP, it's the APC candidate that won the election in Imo. And as such, the PDP candidate should vacate the government house and the governor's seat for the APC candidate to take over. So that is the Supreme Court exercising its powers there as the Supreme Court of the land. So that decision by the Supreme Court became final, and there was nothing PDP could do, no anything the PDP candidate could do. So Imo is now under the APC. So that's Supreme Court for you. Then next to the Supreme Court is the Court of Appeal. The Court of Appeal entertains appeals from courts of superior records of coordinate jurisdiction, as the Federal High Court, the State High Court, National Industrial Courts, any other tribunal, the Securities and Exchange Tribunal, the Tax Tribunal. Appeals go to the appeals goes to the Court of Appeal.
So the Court of Appeal is there to entertain some matters before the parties who are dissatisfied can proceed to the Supreme Court. So there are matters that are final at the Court of Appeal. For instance, election matters, especially National Assembly and State House of Assembly. The final court to entertain such matters, the Court of Appeal. Then we have the Federal High Court. The Federal High Court used to be a revenue court, and it's created by virtue of Section 251 of the Constitution as amended Nigerian Constitution. And if you go to paragraph F of that section 251 sub 1, you get to see what are the functions and the roles of the Federal High Court, the kind of matters, the jurisdiction that the Federal High Court, the kind of matters that can be entertained by the Federal High Court. And if you go, such matters include patent, trademark, all matters relating to patent, trademark, companies, matters between federal government agencies, and does not involve civil contract, policy matters, and the rest. These are things you approach the Federal High Court for. Then we have the State High Court. The State High Court has unlimited civil and criminal jurisdiction, except that it cannot entertain matters that are within the jurisdiction of the Federal High Court and matters that are within the jurisdiction of the National Industrial Court. But it gets to entertain matters that are civil and criminal matters, because that's unlimited jurisdiction when it comes to money and subject matter, and even when it comes to the location and the rest, its jurisdiction is not limited. Then we have the National Industrial Court. National Industrial Court is a court created for the purpose of entertaining industrial matters between employer and employee, trade union matters, between trade union, matters relating to any matter relating to trade union, employment. These are strictly within the jurisdiction of the National Industrial Court. Then we have the Sharia Court. If you are subject to the Islamic personal law, you can approach this court for your matters to be decided based on the Quran and the Hadith. So if you are subject to the Islamic law, then you can approach these courts for your matters. Then we have the customary courts. The customary courts are there to entertain matter based on the custom and traditions of the people of that particular setting. So we have customary courts in Nigeria administering the custom and traditions of people. So basically, customary courts, area courts, their jurisdiction are similar. You can see here we have area courts. It's just change of nomenclature. In the South, you will see they are normally referred to as customary courts. When you come to the North, it's area courts. Even though if you go to some northern states now, the area courts are not there, but you get to see magistrate courts. Magistrate courts is also a court of inferior records. So magistrate courts, they have jurisdiction over civil and criminal matters. Civil and criminal matters, only that it has a limited jurisdiction. It's not, when I say limited jurisdiction, that means it's not all matters that you can take to the magistrate court. Sometimes money, subject matter, if the money is up to a certain amount, you can approach the magistrate court. If the subject matter relates to a particular matter, like land, you cannot approach the magistrate courts. So let's look at civil law. What we see, as the name implies, civil. Civil is just there to regulate relationship between persons. It's just there to regulate relationship between private citizens. That's why we have civil law. It serves to regulate the conduct of persons in their relationship, dealings with other persons, and by so doing, it confers status, rights, and obligation on individuals or juristic persons or companies that are registered. You get to know what juristic persons subsequently in the lectures. So civil law is just there for private citizens. If somebody trespassed on your property, that's civil. It's civil in nature. Then you get to institute a civil case against that person because these are private rights that relate to citizens. That's why we have the civil law. Is there to defamation. It could be either libel or slander, where somebody published something about you and it's false, and you know it's false. You can approach the court and say, "Oh, what this person did, the article he published about me on social paper is false, and this is what I want the court to do for me." Then we have battery, which is beating on somebody. Though battery can be criminal in nature and it can be civil also. So we have the criminal justice. Criminal law is the body of law that relates to crime. It prescribes a conduct passive as threatening, harmful, or otherwise endangering the property and health and safety and moral and welfare of all citizens. So in the case of criminal law is unlike civil law, is different. It's normally written. It's written that okay, if you do so things, this is the punishment you suffer. If you do so things. So it's there to ensure that the state is the country or Nigeria as a whole is being governed properly. So when you kill somebody, even though you committed a crime against that person, but that crime is against the state because it's affecting the operation of the state. You are killing somebody. So in this case, it is the state that will prosecute you. It is Nigeria that will prosecute you, or it's not that private individual. A private lawyer cannot prosecute except given feared by the AG. So criminal law is just there to ensure that people are, are, are punished for their wrongdoing. By so doing, it protects the collective interest of the society. So, as I said, it is always written because Section 35 sub 11 of the 1999 Constitution says that you should not be punished for any offense that has not been written and the punishment defined. So that's why we have the police, the ICPC, the EFCC, all these Yahoo Boys, Money Fraud Act, advance fee fraud, and all other things. So these things are there for the Economic and Financial Crimes Commission to administer. We have the police to also play a role in prosecuting people, especially when it comes to murder. We have the Ministry of Justice. They all play a part. So this is it about the Nigerian legal system. I believe you have an idea of what the Nigerian legal system is. So at the end of the class, there will be opportunity for questions to be asked. But for now, I'll be the only one speaking. At the end of the class, if there are any observations you make or questions you want to ask at the end of this module, you get to ask your questions. So let's move on to relevant regulatory agencies in Nigeria. Relevant regulatory agencies in Nigeria regulating business. Top on the list is Corporate Affairs Commission. We'll talk about the Corporate Affairs Commission in detail. The FIRS, we'll talk about it in detail. Central Bank of Nigeria. Central Bank of Nigeria is the apex bank of the land. It's the highest financial institution in Nigeria. It's the bank of last resort, a bank of bankers. So it's CBN that decides the policy on how the Nigerian financial system will be run by various banks. That's why you see CBN rolling out general policy for banks to follow. Like of recent, CBN decided to reduce the lending rate to, I guess, to 11 something percent, I guess. I can't recall the exact rate. But that's the work of the CBN to ensure that there is economic growth in Nigeria. You see, recently, due to the scarcity of dollar in the market, CBN decided to look at how we remit foreign remittances from how Nigerians in diaspora remit their money. Because people are not allowed to withdraw their money in dollars. People are boycotting the official channels of sending money to Nigerians. Nigerians in diaspora are boycotting the the official channels of sending monies to their relatives here in Nigeria, and they are using backdoors to ensure that it's the dollar that reaches their relatives here in Nigeria. So the CBN looked at it and said, okay, if that's the case, let's solve part of this problem of scarcity of dollar. Let's allow these people to withdraw their monies in dollars so that they will stop using those backdoor channels, and aside aside encouraging them to use the official channel, it also will generate money because definitely they will get to take charges for whatever services they are providing, which they remit, especially VAT. So CBN is just there to ensure that the Nigerian economy is good, and bankers are following the general policy to ensure that the customers are protected and the rest. Then we have the Asset Management Corporation of Nigeria. The Asset Management Corporation of Nigeria, AMCON, was established by the 2020 Act of AMCON. However, it has been amended by the 2019 Act. Yeah, what is basically the function of AMCON? AMCON is just there to ensure liquidity flow in the financial institution in Nigeria. So AMCON, by engages in the management and surveillance of toxic assets within the Nigerian financial institution. When we talk of toxic assets, we're talking of non-performing loans. We're talking of non-performing loans that are loans that people have collected from banks, and they are no longer servicing such loans, so they become bad debts to banks. So by such doing, such monies, if you don't repay such monies to bank will not be able to give out these monies to other persons on loan. So what AMCOM will normally do, they will come and buy off such debts from the banks. So now those people that borrowed money from the bank who are no longer indebted to the bank, rather now they're indebted to AMCOM. For instance, let me give you an example. Let's say there's a company called Skyron Limited. Skyron Limited decided to borrow money from GT Bank, which since they borrowed 1 million and they were unable to, the company was unable to service the loan over time. So what AMCOM will come and do is it will look at the balance sheets of GT Bank and see what are the loans that are not performing. So Skyron Limited borrowed 1 million and Skyron Limited have not been servicing that loan. So what AMCOM will do is they will give GT Bank that 1 million, and now Skyron will be indebted to AMCOM. So AMCOM will now, that's why you see sometimes you see AMCOM will release list of debtors with the amount they owe. It's not like they collected the money from AMCOM. It's because AMCOM went to various banks to check their balance sheets and to see which of the loans are non-performing, and they bought such loans. And now those people that were indebted to the bank are now indebted to AMCOM. So AMCOM is just there to ensure that there's liquidity flow and it reads the market of toxic loans. So let's look at we'll look at the National Agency for Food and Drug Administration later in these days. Then we have the Standard Organization of Nigeria, which we'll also look at it in detail subsequently. Then let's look at when we talk of the FCDA. If you're in Abuja, then you know if you are doing any business that involves land, then you have to approach the Federal Federal Capital Development Authority (FCDA) or its agency, which is AGs, for the purpose of getting allocation to carry out whatever business you want to carry in the district. Whatever business you want to carry that involves land. Or if you're in another state, you approach the Commissioner for Lands or any other person or any other agency created for that purpose. Then let's look at the Corporate Affairs Commission. When we talk of the Corporate Affairs Commission, the Corporate Affairs Commission was established by CAMA. So if you check the CAMA of 1990, the CAMA that established the corp, even though CAMA has been amended several times And of recent, the most recent amendment is the 2020 amendment, which has generated a lot of controversy. But you can see the controversy is dying down as as, as society gets a grip of what the provision is really about. The provisions contains that those provisions that generated those controversies, when as the society is getting a grip of what those provisions meant, the controversy is now dying down. So what it is a regulatory agency in charge of registration and regulation of business and non-business organization. Regulation of business and non-business organization. Business in the sense that you create an organization for the purpose of making profit. Non-business in the sense that that organization is not engaged in profit making, like churches, like NGOs and the rest. So it's all regulated. Business name is all regulated by the Corporate Affairs Commission. So if you want to register a business or an NGO, a church, mosque, the appropriate body to approach is the Corporate Affairs Commission. So what is the function of Corporate Affairs Commission? By virtue of Section 1 sub 1 of the Companies and Allied Matters Act, CAMA, 2020 as amended, sets out the main functions of CAC to include regulation, supervision of the formation, incorporation, management, winding up of companies, and maintain company registry in all states of the federation. So at the stage of formation, CAC plays a part when you intend to form your company, plays a part. After formation, it says that will incorporate the company. After incorporation, it says is still relevant in the management of such company. Even if after you register the company and you feel you no longer want to run the company anymore, CAC still plays a part if you want to wind up that company. Then it maintains company registry in all states. So, immediately you register with the CAC, a file will be open for your company. So for any changes that you want to do in your company, you must file it with the CAC, and that file must be maintained for your company. CAC also carries out investigation into the affairs of the company if the situation demands. So, when registering either of this of the aforementioned, that is business names, companies, incorporated trustees, you will give CAC the objectives, or the nature of the business, of what you intend to go into, why you are registering that business. So if CAC are aware that okay, that you are running the business contrary to the objects you supplied to them, then CAC will carry out investigation, go to court, and they will have that power to, if it is an incorporated trustee, they'll have that power to take over that church or anything, and put in new trustees for the purpose of administering that particular church, or they will take over the administration of companies, depending on the directives given by the court. So we've looked at CAC. So let's look at the Federal Inland Revenue. You see, the Federal Inland Revenue wasn't an autonomous organ back then. It was by virtue of the 2013 Act of the FIRS that it became an autonomous organ. It used to be part of the Federal Inland Board Revenue Service. So after the creation of the FIRS Act 2013, which after the creation of FIRS by virtue of the 2013 Act, it made it to be an independent organ. It's not independent of the Federal Board of Inland Revenue. So what Federal Board of Inland Revenue does now is just to roll out general policy for the Federal Inland Revenue Service. So the Federal Inland Revenue Service is there to is charge of the collection and administration of federal and corporate taxes. So that's the function of one of the functions of FIRS, Federal Inland Revenue, the collection and administration of corporate tax. And by virtue of Section 2 of the FIRS Act, it also has the responsibility to administer and control the different tax and laws specified in the first schedule of the FIRS Act. Different tax and laws, it has the power to control and administer these different tax laws. And what are these tax laws? We have the Value Added Tax Act, we have the Stamp Duty Act, we have the Companies Income, we have the Companies Income Tax Act, we have the Personal Income Tax Act. These are tax enactments that are administered by the FIRS. And the FIRS, by virtue of Section 25 of the Act, is also empowered to administer and enforce the various tax enactments. It enforces them. So if they say you are not paying your VAT, FIRS has the right to prosecute you. That is criminal offense to prosecute you for such, for not paying your VAT, for not remitting your VAT, if it is your personal income tax. So it plays a vital role in the enforcement of such tax enactments. So basically, you see, there are different tax laws, but for the purpose of this module, and considering that the fact that participants in the end will either run a company or run a business, we are going to just look at the value added tax. Let's look at the value added tax and the value added tax act. Let's just, when we talk of the value added tax VAT, which I will refer to as VAT as we move forward, it's just a consumption tax. When we say VAT, we're talking about consumption tax that is levied repeatedly on a product or services being offered to you. For instance, now if you make a call, if I use MTN, if I make a call using my MTN SIM, you will see that it will give me a rate of how much I was charged for VAT for making that call. No matter how many times I make the call, they charge me for VAT, because VAT is a consumption tax that is levied repeatedly on a product as you are using that product, or as you are buying that product, or as that service is being offered to you. You are being charged for VAT. So basically, VAT is a consumption tax, and once you are into the selling of any product or offering of any service, you must always charge for VAT, and the VAT is not for you; it's for the federal government, which you are supposed to remit to your local VAT office. Because once you begin to run a business, you are expected to approach the FIRS to register to get your permanent VAT registration number, which will enable you to be remitting your VAT depending on how you decide to be remitting. Is it weekly, monthly, daily, to your local VAT office, which is the office you registered and obtain your VAT registration number. And it's not all products that are VATable, because if you check the Finance Act of 2020, 2019, you get to see that that particular act increased the VAT from 5% to 7%. And that particular act, you get to see some products that are not VATable. But Nigeria, once there's a law, even products that are not VATable, people just put VAT on it to get money. I don't know whether they limit the product, the VAT to federal government or not, but they will say VAT, everybody will just, they've increased VAT. Even products that are not VATable, people will go ahead and put VAT and also increase VAT. Well, in the first instance, there is no VAT on that product. So let's look at Standard Organization of Nigeria. So when we talk of Standard Organization of Nigeria, we're talking of a statutory body. When we say statutory body, it's created by an act that is vested with the responsibility of standardizing and regulating the quality of all products in Nigeria. Sorry, do away with that all products in Nigeria. It's not all products in Nigeria that is the responsibility of some to standardize and certify, because there are certain categories of products that are meant for Standard Organization of Nigeria to certify and standardize. And there are those ones for NAFDAC. So that what I included there all is misleading. So what are the functions of the organization? So next time I'll do away with this committee. So what are the functions of this organization? The function is to investigate the quality of facilities, materials, and products in Nigeria, to ensure reference standards for calibration and verification of measures, to compile an inventory of products. As you can see, inventory of not all products, inventory of products requiring standardization. So when you get to their site or you get to their office, get to give you an inventory guide. From personal knowledge, I know that once you are into manufacture of certain goods, you need certification, doors, accessories, fire extinguisher, sometimes iron, you see iron, pressing iron, carrying the logo of standard, the mark certifying that that product being certified by the Standard Organization of Nigeria, register and regulate the standard marks and the rest. So these are the functions of Standard Organization of Nigeria. Yeah, let's quickly look at the procedure of registration with Standard Organization of Nigeria. The one we talked of earlier, the CAC, we're going to look at how you register your businesses with CAC in detail subsequently. So let's just quickly look at how you register your product with our Standard Organization of Nigeria. Now, the procedure for registration with Standard Organization of Nigeria is we have the e-product registration and the mandatory conformity assessment program. The e-registration is for all products, for locally or imported products. As you can see on the slide, visit the portal. On the home page, you click on e-product registration, you continue new registration, click on account, you create account, your company's name and RC number, you enter your company's RC number, valid, sign up, password will be sent to your email, go back to your sign-in page and enter the RC number, email address, then the next page requires you fill in the company. After doing it, you click, then payment advice will be issued. You choose the most convenient. It's not as easy as just reading it out or saying it. But if you have any difficulty, you just approach their office or you just contact their customer care on their site. I don't know how effective that site or if there's any phone number provided will be. So you scan and upload the following documents: CAC certificate, picture of the product, RTME, trademark certificate, and the rest. Then we have let's look at the other procedure for registration with SON. We have the mandatory conformity assessment program. The mandatory conformity assessment program is the mandatory product certification scheme put in place by Standard Organization of Nigeria to ensure that all locally manufactured products in the country conform to the relevant Nigerian industrial standards. So that's basically what MANCAP is all about before such products are presented for sale in the market or exported. So what are the procedures for inspection of the production process? These ones are normally for locally manufactured products to ensure that the Nigerian industrial standards are complied with before that particular product is rolled out or is distributed or sent out to be marketed to the public. We have sampling and testing of the product against relevant Nigerian industrial standards of conformity assessment. Report of inspection and test results are applied by state offices and forwarded to product certification if the product meets the requirement. So you have a note and you get to see them. And I will direct you to some certain website you go to where you have details of this procedure of registration with the Standard Organization of Nigeria. But this is not something we can discuss just today because we have quite a lot to discuss. So I will direct you to this site for further information on registration with standard organization. You could just go to www.618biz. You can see it here, www.618biz.com. So when you go there, or you could just go Google, registration with Standard Organization of Nigeria. You get to see so many pages come up. So you get to have an idea of how to go about. Aside those two procedures we mentioned, the e-product registration and the MANCAP by the Standard Organization of Nigeria has also created another conformity assessment program called Standard Organization of Nigeria Conformity Assessment Program for goods shipped to Nigeria. So for details on that, because I logged into the site, the inventory of products I saw there, they're just quite large. So you could just log on to www.cortina, here it is, www.cortina.com, or you could just Google export guide to Nigeria. So that page will come up and you get to see the forms you need to fill. It will come out in PDF format, the forms you need to fill, how you need to go about it. For any inquiry, you could just go to Standard Organization of Nigeria. Their office is at Zone 7, close to where Road Safety Office and close to where NAFDAC office is. So let's quickly look at registration with NAFDAC. This is another, that's why I said not all products that are certified and regularized by some of the products are those meant for NAFDAC to administer. So that's why NAFDAC has the mandate for controlling, maintaining the distribution, advertising, exportation, importation, manufacture, and the registration of the categories of products such as foods, drugs, medical devices. So if you want to go into these categories of products, then the appropriate agency to approach to obtain license or permits to do any of the following: distribution, advertising, exportation, importation, manufacture, distribution, even pharmacy. The pharmacy we have in different locations here in Abuja, they are engaging in distribution. So they will definitely need the a permit from or license from NAFDAC to operate. So all businesses dealing in food and related products are subject to regulation by NAFDAC. And as it is unlawful to market any drug or consumable goods in Nigeria to the public without registration with NAFDAC. So the implication of when you are into the production of any of this aforementioned products within the category of products administered by NAFDAC, and you fail to do so, then definitely your products and goods are not supposed to be made available to the public, because you need to obtain registration NAFDAC. I know over time there's this thing that has been subconsciously built in our mind, which is when we want to buy drugs or anything that is NAFDAC related, we tend to check for the registration number with NAFDAC. So if you are into the production of any of the categories of products administered by NAFDAC, and you fail to obtain NAFDAC registration number, you are affecting your market. Because if I go to the market, I want to buy your product and there is no NAFDAC registration number, definitely you don't expect me to buy. I will say, I want to know whether this particular product is of standard or substandard. And the absence of NAFDAC registration number will validate my thinking. Then what are the categories of products that are administered by NAFDAC? So these are the following. The following products are the products administered by NAFDAC. When you have food and water, when you're into the production of food and water, you need to approach NAFDAC. Drugs and medical devices, herbals and cosmetics, vaccines and biologics, chemicals, veterinary products, and narcotics. These are things that if you are into the manufacture, distribution, or registration, this thing of manufacture or distribution of such, you need to approach NAFDAC, get license to do that. And that's your permit or whatever it is you get from NAFDAC for the distribution and advertising or manufacture of that product. Gives you the right to go ahead and do whatever business in respect of that particular product. So let's look at the procedure for registration with NAFDAC. We cannot pick all these categories of products, just like the standard organization, and say we want to discuss all one by one how you go about registering. So what I did here is I just picked drugs. So we just look at drugs as an example, and even the drugs, we have different medicines, medications, or drugs. So we cannot pick and start discussing for this is how you go about this. So what I just did here is just that I picked the major requirements for registering that drugs generally. And I just looked at drugs generally. So basically, the documentation for the different categories of products administered by NAFDAC may differ. You get it, but there are some things that are constant, whether food, drugs, when you want to register with NAFDAC. The first one is application for approval to bring in sample if the product is not locally manufactured. Then the second arm is application for full registration of product. Full registration of product, that is when you get to fill those documents. So let's look at, so for detail, you can go to 7, or you could just log into the website of NAFDAC. Because recently NAFDAC introduced an e-method, e-procedure of registration too. We just looked at that briefly. I can't tell you how effective that procedure is. But we'll also look at that briefly at the end of, after we looked at these key requirements for registration of drugs. What are the key requirements? When you want to register your drug, application is on a single product basis. When I say application is on a single product basis, I'm basically saying that if you have different drugs, for one is for stomach ache and the other one is for headache, what you need to do is you don't combine the application together. The application is separate. Separate one for that medicine for headache, separate one for that stomach ache medicine. So application is on a single product basis. Then you have a written application stating the name of the manufacturer and brand name if applicable. Then you complete your NAFDAC application form. You get to attach your certificate of incorporation with the Corporate Affairs Commission if you are running a company. Even if you register subsequently and you want to obtain NAFDAC registration number, you need to do that. You need to attach. And you have 5 copies of the product dossier. When I say 5 copies of the product dossier, what I meant is, if you are into production of drugs, you must have carried out series of tests, trials, and the rest. Like for instance, with the corona vaccine now, that's before approval, before the UK approved it, it had gone the one produced by Pfizer and biotechnology. It has undergone several trials, medical trials, before it was approved by the UK. I don't know the board there that are in charge of their own NAFDAC equivalent in UK there before it was approved. So you need to attach that product dossier. Then you bring 3 packs of the product samples, notarize original copy of the duly executed power party. Let me not just, when I say notarize original copy of duly power party, especially when you are importing, before you are allowed to import a drug, let's say Pfizer, for instance, this new corona vaccine, you want to import it to Nigeria. Anyone that has that contract, that's a huge contract for that person. So definitely you need a power of attorney from Pfizer authorizing you to import and distribute that product in Nigeria, that particular vaccine in Nigeria. So power of attorney is basically a document that empowers you to carry out uh, a tax on behalf of somebody. So what NAFDAC is simply telling you is that, okay, that particular document that gives you the power to come and distribute that this product in Nigeria, you must notarize it. That means it must be signed and stamped by either the High Commission in India, let's say Pfizer is in India, or in the absence of the Nigerian High Commission, you can approach any other ECOWAS mission house. In the absence of ECOWAS mission house, you can approach the British embassy there to notarize that document for you. So there's also certificate of manufacture issued by a competent health or regulatory authority in the country of origin and authenticated by the Nigerian mission in that country. So that also has to be certified, has to be notarized. There is also a contract manufacturing agreement. In the absence of of power of attorney, sometimes you just, especially you've gotten a franchise to manufacture the product in Nigeria, you to you get to you get to you get to sign a manufacturing agreement. So that manufacturing agreement also has to be notarized. So in the country of origin. So that means you approach either, if it is a Commonwealth country, you approach the Nigerian High Commission. Where it is not a Commonwealth country, you approach the Nigerian embassy in the absence of either to go to ECOWAS mission or the British High Commission or the British embassy. Then, as I said earlier, it's not just manufacture, advertising, even distribution. So if you want to open a pharmacy to distribute drugs, you also need to obtain permit from NAFDAC. So, and in accompanying your application to NAFDAC, you need to attach your certificate of pharmaceutical products really issued and authenticated, current superintendent pharmacist license to practice issued by the Pharmaceutical Council of Nigeria, premises registration license from the Pharmacy Council of Nigeria, the certificate of branding trade registry in the Ministry of Commerce. Because sometimes, if you, especially when it's a brand name, NAFDAC will require you to bring your certificate of trademark registration. And the only way you can get that is when you have registered with the trademark registry under the Ministry of Commerce. Then we have you pay the applicable fee only if documents are confirmed to be satisfactory. Then I told you earlier, NAFDAC has introduced an e-registration method. So what this e-registration method is called the NAFDAC Automated Product Administration and Monitoring System, which is called NAPAMS. So definitely, if you go to www.napams.org, sign up, register an account as a client. After signing or logging in with the register account, you choose the category of product you want to register. After you've met precondition met for registration, especially when you're importing, you need to complete the application and the forms and the rest online, pay the applicable fee, you process your application and obtain certificate. It's not as easy as stated here or listed here. So sometimes you can use agents if you think it's going to be stressful for you, carry out such things. But where you can do it yourself, or you can go to Zone 7 NAFDAC, make inquiries, or you can log into their site. Once you log into the site, the procedure for the registration and the rest is not that hard, it's straightforward to do. So we've looked at the relevant agencies regulating business in Nigeria so far. So now let's look at types of business organization. What are the types of business organizations we have in Nigeria? What are the types of business organization? The types of business organizations we have in Nigeria and the legal implication of the various types of business organization. So let's quickly run through this. When we say business organization, we are talking of a legitimate venture to make profit. get it, it must be a legitimate venture to make profit. It must not be an illegitimate venture. It must be a legitimate venture to make profit. And what are the types of business organization? We have a sole proprietorship, we have partnership, we have company. So let's quickly look at sole proprietorship, partnership, and company using certain examples to enable you to comprehend what this type of business organizations are and their legal implications. So let's look at sole proprietorship. When we talk of sole proprietorship, as the name implies, he's the sole owner of the business. Sole owner of the business. He owns the business alone. He decides, he makes decisions alone. He if he likes, he spends the profit. Nobody question him. There's nobody to tell him this is the way you should run your business. It's just, for instance, Mr. Johnson running Johnson Ventures business, Johnson Business Ventures. So Mr. Johnson is the owner of Johnson Business Ventures, and he's the sole owner of that business. He runs his business the way he wants to run it. If he likes, he spends the profit. If he likes, he spends the capital. If he likes, he invests. He takes the decision alone. If he dies, the business dies with him. So these are this sole proprietorship. The owner of the business is alone in charge, and he takes all the decisions alone. So what are the implications of running a sole proprietorship? First, he dies with the business. Secondly, when he borrows money, when Mr. Johnson borrows money from the bank, he's personally liable. It's not Johnson Business Venture that is liable, it's him. Moreover, if you borrow the money, you borrow it in his name, not in the name of Johnson Business Ventures, because the bank will look at what are the collateral available for them to grant him that loan. So where he obtains that loan and he's unable to pay, he will be personally liable for the debt and liabilities of that business. So once the bank wants to come for its money, it's going to go after him. The bank will go after him personally. That means they can seize his personal cars, they can seize his personal cars, they can seize his properties, personal house, anything they can lay their hands on to recover their money. So even with sole proprietorship, if the business is registered to the it's not a separate legal personality, but the sole owner still remains the sole owner, and the owner's personal asset and business are inseparable from that person. So he's still liable. Then we have partnership. Partnership is when two or more persons come together to run a business for the purpose of making profit. But one thing with partnership is that partnership can be general partnership and it can be limited partnership. When we talk of general partnership, it's just when two or more partners decide that, yes, we want to be partners, but we want to be actively involved in the running of the business. So in that case, what is the legal implication for saying you all want to be involved in the running of the business? The legal implication is that all the partners are personally liable. Let's say Mr. John Johnson, and James decide they want to run a partnership. So that partnership they want to run, and they said they all want to be general partners. They want to be involved in the day-to-day running of the business. So by taking that decision to be involved in the day-to-day running of that business, they are all personally liable. So their assets, their everything, personal things can be seized to offset that particular debt where the business borrows money or the business runs into a debt. So they will definitely be liable. Then we have limited partnership. Limited partnership is when one or two of the partners decide that they don't want to be actively involved in the day-to-day running of this business. They just want to invest and sit back and gain their investment. So let's say Mr. John Johnson and James into partnership, and Mr. John said, see, Mr. James and John, I just want to invest. I don't want to be involved in the day-to-day running of this business. Any profit you make, you give me my own share. I'm satisfied. So where they borrow money and the bank is coming for, or any organization they borrow the money for is coming for its money, Mr. James, who said he wants to be a limited partner, his liability will only be limited to his investment in that business. They cannot come after him personally. Unlike in the case of general partners, where they can come after him personally. That's why here we have general partners are at risk of having their personal belongings seized to offset the debts and liabilities of the partnership business. Because a business made up of two or more partners, each sharing the business's debts, liabilities, and assets. A limited partnership exists when two or more partners go into business together, but one or more partners are only liable up to the amount of investment. So you can see. So once you are entering into partnership, at the point of the discussion, drafting the agreement, that's the point you decide whether you are going to run as general partners or as limited partners. So, and there's one thing with partnership: profits are to be shared equally among the partners, except expressly agreed otherwise, except parties. If and for you to be regarded as a partner in a business, you must partake in profit sharing. You don't partake in profit sharing, you're not a partner. Let's say Mr. John is running a business, then he approaches Mr. Johnson and says, Mr. Johnson, you are my partner. But Mr. Johnson has never partaken in the sharing of that profit. Mr. Johnson cannot go and be portraying himself as a partner in the business of Mr. John because he doesn't partake in the profit sharing. So it's major once you are taking any partnership agreement or you are entering into any, you decide that you are going to partake in the profit sharing. So let's look at companies. There's something about companies that is unique. There's something about company that is unique, unlike sole proprietorship and general partners, with the exception of limited partners. Just like limited partners, that's how company is. From the day you are issued with your certificate of incorporation, let me use Mr. Johnson for instance. Once I use this example, you get to know why companies are unique. Mr. Johnson is the owner of Johnson Business Venture. Then suddenly decide that no, he doesn't want to run sole proprietorship anymore as Johnson Business Ventures, duly registered with the Corporate Affairs Commission. Then Mr. Johnson will say, okay, I want to upgrade. I want this my business name to be a company. Then he decides to register, change the name to Johnson and Johnson Nigerian Limited. So what I'm saying here is that from the date of issuance of certificate to Johnson and Johnson Nigeria Limited, Johnson and Johnson Nigeria Limited has now become a juristic person. Is a separate legal personality from Mr. Johnson. So nobody will approach Mr. Johnson and say, you are the owner of Johnson and Johnson Limited. So your Johnson and Johnson Limited borrowed money from us. So he has the one that is supposed to pay money. No, unlike sole proprietorship with companies, it works differently. It is Johnson and Johnson Limited that is liable for any debt collected in the name of Johnson and Johnson Limited. Even though it's Mr. Johnson that will go and facilitate the loan in the name of Johnson and Johnson Limited. But once the loan is collected in the name of Johnson and Johnson Limited, and let's say the bank wants to recover its money, it is going to be anything the bank wants to recover or wants to sell after going to court or want to attach for the purpose of satisfying that debt, it must be properties belonging to Johnson and Johnson Limited, not personal properties of Mr. Johnson. Highest, Mr. Johnson can only be a shareholder or a director in that company, and his liabilities are limited to his shares in the company. So once he has paid his shares in the company, nobody will come after him that he should pay the debt of that company. So company becomes an artificial person from Mr. Johnson, who is the natural person, even though he's the promoter of that company. So personal asset of shareholders cannot be seized to offset the debts and liabilities of company. Then what are the legal implications of, aside the one I mentioned, what are the other legal implication of registering a company. One, as a company, it can buy and own properties. The company can buy and own properties. Aside that, the company can enter into contract. It can enter into contract with anybody, a juristic person, as long as that person is a juristic person and the contract is valid. A company can sue and be sued. That's why you see some matters in court. Those of you who are familiar with the happenings in court between two companies in court, because that the law, in the eyes of the law, that company are juristic persons, they are artificial persons, so they can sue and also be sued, and they enjoy perpetual succession. That means it can live forever as long as there are change of directors and shareholders. I like to use First Bank as an example when I come to perpetual succession. Because if you check the logo of First Bank, you will see created since, I don't know, you will see the date, 1895 or something. Are you telling me that those people that began First Bank are still alive? No, because First Bank is an artificial person. That's why it has this character of perpetual succession. That is why it lives forever, is there forever. So aside the fact that it can live forever, different shareholders can come and go. So First Bank, different shareholders have come and gone, different directors have come and gone, but come rain, come shine, because it's still First Bank. First Bank. So you can see that companies can live forever. You can also apply for loan in the registered name. So let's quickly look at the registration of business and non-business organization. We're going to look at registration of business and non-business organization. And you can recall earlier, if you recall earlier, when we were talking of CAC, we did mention that there are one of the functions of CAC is the registration of business and non-business organization. So why register your business? Why do you have to register your business with Corporate Affairs Commission? Registration is done with the Corporate Affairs Commission. Any business, whether small or large, will in the long run benefit from the corporate and physical and product registration. A registered business with corporate affairs is unknown to law. One, you don't get to enjoy some incentives. For instance, let me give you an example. The survival fund being disbursed by the federal government. If you have a business and it's not registered and you don't pay your tax, how can you enjoy such incentive? Or you are running a business and it's not registered, how can you approach the bank and tell the bank that I want to borrow money when your business is registered? Because banks, before they even lend you money, especially when you approach them in the name of your business, that business must be registered. So that this, and if your product is unregistered with NAFDAC, it's also a problem that affects your sales, and your premises might be sealed, resulting in huge losses. So registration for tax is also, and you get to pay your tax once you register, and it's a civic duty. It's a civic duty once you pay your tax, you're doing a civic duty. So this is why we need to register our businesses. So let's look at the procedure. Okay, small startup procedure. You don't have a business now, or you have one, or you don't have one, you intend to start one now. What are the things you need to look at? Basically, there are some basic things you need to look at. Find a suitable business name to support your business idea, which is the most important thing. After you must have done some preliminary investigation, like identifying suitable business location, get a name, register with the business name with CAC. Make sure you choose a name that is easy to pronounce and remember and has a relationship with your type of business. Then register with FIRS, Federal Inland Revenue Service, as your value-added tax collection point. That means, when we talked about VAT earlier, I mentioned the fact that you need to to register with your local VAT office to make your taxes. As we said, VAT is a consumption tax that is levied repeatedly on a product. And you register with standard organization where the categories of products you want to go into falls under the inventory of products that is administered by standard organization of Nigeria. So let's look at procedure for registration, procedure and documents to be submitted to CAC for registration of business name. But before we discuss, you need to get an idea of business name. Business name, comma, under the comma, we have part A, B, and C. And I guess part B is business name, part A is companies. So if you don't want to register, you are running a business and it's not registered with the CAC, and you don't want to register that business as a company, you have the option of and you want to make profit, you have the option of registering that business as a business name, not necessarily as a company, it having the characteristics of a company. You can just register that particular business as a business name. But if it's non-profit making and you want to register with the CAC, you can still register it as an incorporated trustee. I just want you to get the difference before I start discussing. So you run a business, you don't want to register it as a company, you can register it as a business name. But you know the implication of registering it as a business name. There is no legal personality. What we talked about in sole proprietorship applies to you once you register that business as a business name. But you can take loans in the name of the business. But if the bank is going to come for that loan where you default, it will come after you personally. It's not like in the case of company where it's those things you bought in the name of the company that the bank will come after. So before you register, there is one thing. If you want to register with CAC, you go to their website. There is an option introduced by CAC now. You know, CAC have accredited agents. These agents will register for you if you approach them. And who are these agents? They are lawyers, chartered accountants, and chartered secretaries. These are people that are agents with CAC. They can register for you. And there's also a provision by CAC where you, as the owner of the business, you can go to their website, register, get a portal, and register yourself. But except your IT IQ is at a level that's very high, that you can easily identify things, that you can easily find your way and do your things. I will advise you, if you can't do it, please approach an agent. You pay him his professional fee. You don't have to worry about anything. All you need to worry about is payment. He will do all the things to ensure that you get your certificate. But if you feel you can do it yourself, you can go ahead. So let's say you are registering yourself. After you gotten your portal, or you are using an agent, let's say, and you've paid that agent. Either way, the next step is reservation of name. You know, when we're talking about startup procedure, we said get a suitable name. You've gotten a suitable name. After you've gotten a suitable name, and you want to register with the Corporate Affairs Commission, the next thing you need to do is to reserve the name. And in reserving a name, you have to choose a name that, one, is not similar to an existing name, two, is not a name that is in use, three, the name must not carry Abuja or International Chamber of Commerce or anything that will stop you from your registry, from the name being approved by CAC. Normally, if you want to enter the name, it will just come out with names that you are not supposed to enter. You get it? So the portal will just bring that. So once you submit that name, CAC will look at the names. After CAC have gone through the names, looked at the name. They will look at is it in line with any of is it contravening any of their provisions in approving name? Is it a restricted name? Is it a restricted name? Is it a name similar to another name? If it is not, CAC will approve it. Then they will send a code to you. There's a code that will be sent to your email under with the approval note. The approval note will contain a note for you, which you will start your registration with. That registration you will start with, that code will direct you to a portal. You enter that code in your portal, then the code will direct you to another portal where you begin your registration. And in that portal, there are forms for you to fill. Forms like the proprietors, the name of the nature of the business, the proprietors of the business, you fill in their information, their personal information, you state the nature of the business, and you get to state some information on the national identity or the driver's license or voter's card or international passport. So these are things you need to have while registering with the CAC if you want to register a business name. Then after you've registered, you've entered all the necessary information, then you make payment. Sorry, with regards to reservation of name, the name is reserved for 60 days until payment. Once you've not paid after 60 days, you've not made payment to CAC and you've not filled your form and made payment to CAC after 60 days, the names expire. The name will expire and you lose the name. So the implication is that that name is available for any other person to use. So after you've filled in the necessary information, you've made your payment, you will download the form. After you've downloaded the form, you sign. You sign, you will attach passports, size of photograph of the proprietors. Then you upload together with notice of approval, evidence of payment. There is a particular section created by CAC for the purpose of uploading. So all these things are not as easy as I'm saying. So sometimes these things can be technical. So because they will want you to follow, if you want to upload that document, if you want to upload documents, CAC would like you to follow a certain procedure. If not, your registration will be queried and you will suffer a setback. So that's why I say if you can't do it yourself, to save yourself that stress of all these, oh, I'm not getting it correctly and the rest, code and code, then you need to get an agent who just charge you professional fee. After you've uploaded the document, CAC will look at it. If there's nothing to query, an approval email will be sent to you with the registration number of the company. Then later they'll tell you courier service to go pick up your certificate from. Then examples of business name are Taiwan Co, Global Ventures Farms, Johnson Business Ventures, etc. So let's look at procedures and documents to be submitted for registration of company. You know, before we talk about the procedure and documents, we have different types of company. We have the private limited company. We have the we have the private we have the private limited company. We have somebody saying okay. We have the private limited company. We have the public limited company. We have company limited by guarantee. Then we have unlimited company. So but for the purpose of this model and the purpose of this class and this program, we're going to just pick the private limited company and the limited company. And we are going to streamline further to just private limited company. Because I guess most participants will engage in small businesses. Small businesses with starting up with family members as shareholders and directors, which the recommended company will be the private limited company. So a private limited company going by the new karma, this 2020 karma, with one shareholder you can register a company. With one director, you can register a company. But CAC, note, CAC have not they are yet to implement the provisions of the new CAMA. So we are still using the provisions of the old CAMA. So if you want to register right now with CAC, you want to register a company, make sure if it is a private limited company, you have at least 2 shareholders, and the highest you can go is 50 shareholders, and at least 2 directors. Then if you want to register a public limited company, you have to have at least 2 shareholders and unlimited number of shareholders. So public companies are usually quoted at the stock exchange. So once you start the fact that you start your company with a private limited company does not mean you cannot upgrade. You have vision that the company, even though it's small, is going to be a public limited company. One day you will sell shares and it will be quoted in the Nigerian Stock Exchange and the Securities Exchange Commission, and you get it. So you can upgrade subsequently. Then you have private company, which is more suited for small and medium businesses. So if for the purpose of this class, it's the small and medium companies you are going to run, small and medium businesses. So all you need is a private limited company. You start with at least 2 shareholders and at least 2 directors. So what is the first step you need to do? You've gotten a name, just like business name. Is the name restricted? Is the name in use? Is the name similar to another name? You need to look at all these things before you submit the name for reservation. You will submit the name for reservation. So if you check all these things and they are not in use, neither are they similar or anything, you submit your name for reservation. It's 60 days. The names are reserved for 60 days, highest max, until payment. Once you've made payment, it means you've filled all the forms and you've made payment 60 days. Then the name will be approved. If the name is approved, a code will be sent to you, to your email, and to your portal. You download that code, you get the code on the notice of approval. You need to keep your notice of approval. Anything you are getting from CAC as a result of an act, what you give them is what they give you back. So anything you download and keep it, because eventually you upload it. The first thing you need to keep is your notice of approval, because in the end you need to upload it. The code, the availability code will be on it. You will enter the availability code. It will take you to another page. That page is the page you get to fill in details like the name of the company. It will come out automatically with the name of the company. What is the share capital of the company? And when we talk of share capital of company, we are saying how much is the company worth? How much are you starting that company with? And the minimum you can start a company with, you can register a company with the CAC is 1 million. 1 million. When I say 1 million, I'm not saying you are going to pay CAC 1 million. It's just an artificial valuation of the company. You are telling CAC your company is worth 1 million. You are just telling CAC your company is worth 1 million. 1 million share capital. That's what you are telling CAC. But there's a registration fee you pay for every million. If it is 2 million, there's a registration fee you pay. If it's 3 million share capital, there's a registration fee you pay. And then you will need to divide that 1 million into ordinary shares to the different shareholders. You need to have at least 2 shareholders. So you have 500 ordinary shares of ₦1 each. So it's the first page. And subsequently, we enter the data of the directors, your means of identification, international passport, driver's license, all these are needed. Then you duly completed CAC forms, you fill them, you put in details. There's where you get to meet your memorandum of articles of association. As you are filling each form, it's taking you to the other form. You are filling the form, it's taking you to another form. You are filling the form. So you come across memorandum where you get to fill in the objects of the company. So let me tell you, if you don't know how to do this thing, there are lawyers who are agents you can contact to help you to do all these things. But it comes with a cost. If you can do it yourself, go ahead and do it. Because there are objects you need to fill in, and articles of association that you can just simply adopt. Objects are just, you're telling CAC that this is what the company will engage in, and objects regulates the activities of the company. Then while articles of association, object regulates the activities of the company with outsiders, while article of association is there to regulate the activities of the company within. So after you build everything, you will make your payment, and there's stamp duty to be paid. Also, at the point of reservation of name, there is payment to be made, and there are remitter charges. So even the money is at a set fixed sum. By the time you add up remitter charges, it will increase the amount. So this is just it. So after you imputed necessary information on the portal and everything you've done correctly, then the next thing you need to do is, you've made your payment, is to download the document. Once you download the document, you will now sign. Your directors, shareholders will sign the document. Then you attach your notice of approval, you attach your evidence of payment, you attach the registration forms, then you upload. And there's a procedure for uploading. Once you upload that, CSC will go through it and see if you've met all the requirements. They'll approve your company. Voila, you have a company, and is now a juristic person. So basically, this is it on the procedure and documents to be submitted. So I'm going to show you a slide. That slide is just to give you an idea of how you pay, how much you pay to CAC for registration of company. But bear it in mind that these fees are something that are subject to, to policy change. For instance, private limited company, Kama, the old Kama will tell you is, you want to register, the minimum share capital is 10,000, for public company 50,000. But you see, CAC is telling you here it's 1 million. So you get it. So these are policy, these are things that are subject to policy changes. So it's just to give you an idea of what it will cost for you to register a company with the Corporate Affairs Commission. So you can see fees, 10,000, 1,000, the rest. You have registration of companies under Part A of Karma, company for 1 million share capital, and the rest. All these ones are just there to like give you an idea. So let's quickly look at our final topic, which is the law of contract. Let me bring it to your notice that the law of contract in itself is a course in law. And if you get to see the Nigerian textbook alone, it's not something you can exhaust within. While in the university, it took us a year to exhaust it. Then within, yeah, it took us a year to exhaust that law of contract, because it's a course in our 200 level back then in the university. So what I just did there is for you to have an idea of what law of contract is. And I believe for those that did accounting and the rest, business administration, we also did law of contract. Maybe not as detailed as lawyers would do it, we treat it, but at least you did it well in your university or any polytechnics and the rest. You did law of contract. So why even we get to why do you have to know about this law of contract? Because by the time you register your business, everything you'll be doing is either you are providing service, which is a contract, or you are selling something, which is also a contract. People think that contract is when we sit down and write documents and sign. No, contract, as we look at subsequently, takes different forms. You get to see different forms of contract. So let's look at what contract is. Contract is just an enforceable legal obligation agreed upon by parties. There must be consensus between parties. There must be agreement. I guess we consent to the fact that we want to be bound by this agreement. What are the elements or features of a valid contract? What are the three basic elements? Let's first of all discuss three basic elements of contract. We have the offer, the acceptance, and consideration. When we say offer, Mr. Johnson wants to sell his car to Mr. John. He approaches Mr. Johnson. Mr. Johnson, Mr. John, I have my Mercedes-Benz Street Art here. I want to sell it for 50,000. That's Mr. Johnson making offer to Mr. John. Then an offer can be in another form. Offer can be when you go to a supermarket, you see them display their products on the shelf. When you pick a particular product and you approach the cashier, that is you making an offer to the cashier that you want to buy that product. Then there are invitations to tender. Advertise on newspaper. You see this government agency is calling for tenders. That tender is an invitation to treat. Then you submitting your application for you to be given that contract is you making an offer to that government agency that you want that contract. So you see, offer takes different forms. Then after offer, there must be acceptance. Parties must accept. When Mr. Johnson approached Mr. John to sell his car, Mr. John must accept the fact that he wants the car. If not, there will not be contract. And further to acceptance, there must be consideration. There must a thing of value must have exchange hand. There must be money. Money must have exchange hand. So there must these elements of contract must be available. And it doesn't matter how much you pay. Once there's value, there's value. Even if it is something of 50,000 naira, and you pay 500 naira as installment. There's value. Value as exchange hand. There is contract. So that's why in law we say consideration has passed. Once you agree on an amount and somebody pays even a fraction of that amount, and he pays it in the name of not deposit to as part payment for that thing, then consideration is passed. You cannot come and say, no, we agreed to 5,000 naira and he paid only 500 naira. There is contract because the thing of value are exchange hand. Then, as I said, form of contract, the contract, the form of the contract matters. It can be written, it can be oral, and it can be by conduct. Contracts must not always be in writing. Sometimes parties will just agree orally, but it's proving it that is the problem in court. So it's advisable you have it in writing. It can be by conduct. Sometimes you enter a cab without even saying a word, because you already know that this is the last bus stop and this is the amount it will cost. Once you reach there, you know that this is his last bus stop. Just give him the money, because he knows the money. That's contract by conduct. Now we have capacity. At the time you are entering that contract with any person, that person must have the capacity to enter that contract. Capacity in the sense that he must be mentally fit. You cannot just go and enter contract with a mad person, somebody who is mentally challenged. You cannot just go and enter contract with that person. Then in such a case, such contracts are not valid. Or you cannot go and enter a contract with a minor, somebody that is not of age. Even though in Nigeria we don't have a law that says this is the exact age that will be considered as age of that you've reached, you are now an adult. But we know that if you want to do registration for voters registrations, voters registration card must be 18. And other things you see 18, marriage 18, other things they will put 18. So let's just leave it at 18. But however, the law is saying that there are some contracts which minors will enter, and such, even though that person is a minor, that contract is binding on him, where it involves his necessity, something that is of necessity to him. Such contracts are valid. Let's say book that he needs to go to school with, that contract will be valid. Then such contract must be legal. As we said, contracts are enforceable legal obligation. If it is an illegal contract, it's not enforceable. Like a prostitute cannot approach the court and say she wants to enforce the contract she entered with her client. He slept with her and refused to pay her money. Such contracts are illegal ab initio and they cannot be enforced. You have intention to create legal, there must be this intention between parties to create legal obligation. Let's look at what privity of contract is. Privity of contract is simply that only parties to a contract can sue. If you're not a party to a contract, you cannot sue. You know, in contract, there must be parties. When I say parties, that means there must be Mr. A, there must be Mr. B. You always have Mr. Johnson and Mr. John coming together agreeing that they want to enter that contract. So let's say that car, that 330, Mr. Johnson wants to sell to Mr. John, and he eventually sells the car. Then Mr. John discovers there's something faulty about the car. Mr. John's wife cannot go ahead and sue Mr. Johnson because Mr. Johnson did not enter the contract with Mr. John's wife. He entered the contract with Mr. John. That's why that's just privity of contract for me. That's the simplest term I can break privity of contract. Only parties to a contract can be sued and be sued. So though that's the general rule, there is an exception to that general rule. There are certain cases where parties to a contract, parties who are not persons who are not parties to a contract can sue. For example, covenants running with land, estates, estate covenants. Let's say Mr. Johnson bought a land in one estate at Lupe, and that estate said, if you are to build your house, it must all be, the fence must be at certain meters. Then suddenly Mr. Johnson sold the house to Mr. John. Mr. John, the fence was at 15 meters, decided to raise it to 30 meters. In that case, even though he bought the property from Mr. Johnson, the estate management can sue Mr. John and say he's violating the estate covenant. So that's an exception to one of the exceptions to privity to contract. Then when we talk of terms of contract are simply the words that you agree. I'm going to sell my car to Mr. John, and Mr. John is willing to buy the car at the rate of so amount. These are the conditions for buying the car. And Mr. John will pay the money upfront. You pay the balance. You pay the 50 naira upfront. You pay the remaining balance in installment and the rest and the rest. These are just terms. So these terms can be expressed and they can be implied. Expressed in the sense that they are all written out for parties to see that, okay, these are the terms of the contract. Then implied is those ones that come with the express terms, even though they are not written clearly. But it is implied that at the time he's buying that car, the car must be moving from point A to point B for a certain period. It's not that when he buys the car today, tomorrow, the car stops moving. That means there's something faulty about that car. So that term can also be implied that even though it's not written that the car must be in a good condition, that particular term can be implied that, okay, you sold the car to him, even though it's not stated expressly in the condition, in the terms of the agreement that the car must be in a good condition. It's implied that that car must be something in a good condition before it was sold to Mr. John. So this is a term, even though the courts on most occasions will rarely want to imply a term to a contract. They would like to interpret it the way parties agree. So it's advisable for you to state all terms expressly in any of your agreement. Then vitiating elements in the contract. What are those things that can vitiate a contract? We have duress. When we say duress is when you make somebody to enter into a contract by force. You are forcing that, you threaten that person. It could be by physical violence, or you could threaten him using another person, a member of his family. And you're going to, if he doesn't enter this contract, you're going to do this, do that to him. As such, that contract will be vitiated. Then we have undue influence, where you have an influence over the person, especially when there is a fiduciary relationship. There's a relationship of confidentiality, where that person relies on you to give him some advice, especially expert advice. You influence him to go and enter into a contract that is favorable to you, not to him. Such contracts are vitiated. And there are situations where undue influence can exist, where there are no fiduciary relationship between parties. So it can exist. So another thing that can vitiate a contract is misrepresentation. This is when at the time of the contract, or before or at the time of entering the contract, you misrepresent facts to the other party. Mr. Johnson will say, this car, the tires I just bought them last month. They are in good condition. The engine itself, I just did some minor repairs. I even changed the engine. He misrepresented facts to Mr. John. In that case, such contract will be vitiated for misrepresentation of facts. Then we have mistake. Mistake occurs when the subject matter of the contract is no longer in existence. Let's say that car that Mr. Johnson wanted to sell to Mr. John. Let's say in the course of the negotiation, unknown to them, and at the point of making payment, unknown to them that Mr. Johnson's son has, in the process of where he has had an accident with that car. One thing or the other occurred, and the car got bumped. So frustration has occurred. The subject matter of the contract is no longer in existence. So in such a case, that contract cannot be said to be in existence. Or where Mr. Johnson has two cars, Mercedes and BMW, and he approached Mr. John that I want to sell the Mercedes for 10,000 naira. I want to sell the BMW for 15,000 naira because it's newer. But Mr. Johnson thought that, Mr. John thought that Mr. Johnson wants to sell the BMW and the Mercedes for 15,000 naira. Then he pays 15,000 naira. That contract is frustrated. Sorry, that contract is vitiated by virtue of mistake, because there is mistake on the part of the parties that is Mr. Johnson is thinking Mr. John is paying that 15,000 naira just for the BMW. When Mr. John is thinking, I've paid 15,000 naira for the two cars, it does not work that way. So there's mistake. So this element can vitiate a contract. Then we have discharge of contract. How can contracts be discharged? Contracts can be discharged by performance, where parties have performed their own parts of the contract. Mr. John offered to sell his car. Mr. Johnson agreed to buy the car. Mr. Johnson pays the money to Mr. John. Mr. John gives the car to Mr. Johnson. Voila, contract is let's say contract is performed and parties are discharged from the contract. Frustration, the example of car I gave you where the car was no longer in existence at the time of entering the contract. Definitely no contract can go ahead because the subject matter of the contract is no longer in existence. In such a case, such contract too is discharged. Then we have fundamental breach. When I say fundamental breach, I mean, let's say for instance, you want to buy a phone from Jumia and you order for an iPhone 10. Then the Jumia supplied you with one Samsung 7 series. There's a fundamental breach of that contract. As a result, that contract is breached and is discharged. Then parties can also terminate contract by a mutual agreement. Parties can just agree that, okay, we no longer want to carry out that agreement we enter. This is common with football, where you see some teams that want to do away with their coaches, they reach a mutual agreement that, okay, parties have agreed. So you see, to part ways, these are mutual agreements. So what are the remedies for breach of contract? One is damages. Damages is just monetary compensation. Telling the court to give you monetary compensation for that other party for breaching the contract. Then we have specific performance. Specific performance, you are just approaching the court and telling the court that the court should compel the other party to carry out its part of the contract. Specific performance is an equitable remedy. It's at the discretion of the court, and the court rarely grants specific performance where damages will be adequate, except in the cases of land where the damages will not be adequate. Then the court will order for specific performance. Then we have ratification. The court can alter or can change the nature of the contract. Let's say Mr. Johnson is to supply 50 bags of granite, and he ended up supplying 20 bags of granite. Court can just decide, okay, since he has supplied you 20 bags, why not just pay him for that 20 bags instead of the 50? That means there's a ratification of the contract by the court. Then you can ask for injunction. Injunction is just a remedy where you are asking the court to stop the other party from doing something. And sometimes, depending on the circumstances of the case, in court, you can ask for what is called mandatory injunction. That is, you're asking the other party to do something, even though injunction normally is restraining the other party from doing something. An injunction could be perpetual, it could be interlocutory, it could be interim injunction. Then we have what we call a quantum merit, which is reasonable value of service offered, where you tell the court that I've offered a reasonable service to this man. So this man ought to pay me certain amount of money for the services I've offered to him. It's just a remedy. You saying you offer this reasonable service and you are entitled to your wages for that service you offer. Let's say you are building for somebody and you reach the level and the person decides to stop, to say that you should stop building, and he did not give you any reasonable reason for asking you to stop. So you can approach the court and say, okay, for that level of construction that I've done to Mr. A, I'm entitled to so amount. And finally, we have rescission, where the court will declare the contract, will rescind the contract. The court will say there is no more contract between the two parties. So thank you very much. That is the end of today's lecture. I believe you have uh, uh, gotten what I want you participants to understand. Because if you could recall, when we began this lecture at 10 minutes past 10, I said there are certain things I want you participants to be able to know. So we've come to the end of the lecture. So now it's time for questions, observations, and contributions. If you have any, this is the time for you to do so. If you have any question, contribution, anything you want to ask, this is the time for you, for those that are still around. Because we started with quite a number, now we are just 6. So if you have any question, now is the time to ask. Question? Questions? Are there questions? I'm going to give you like 2 minutes. After 2 minutes, there's no question, we proceed. We don't have any other model. This is the last class for today. So, okay, Mr. Bako, you can ask your question, but you unmute yourself. I don't know whether you have a question, but I can see you raising your okay. You are lowering your hand now.
Good morning.
Okay.
Hello?
Yes, I can hear you, even though it's faint.
My question, I have not registered my company, but I have a friend who registered his company. Can I use him as a joint venture to apply for the loan?
You have what?
I said
Sorry,
I have a friend. I said I have not registered my company.
Yes.
But a friend of mine has registered his own company as one of the agro-based company that processes ginger.
Yes.
So
Sir.
my question there, can I have him as a joint venture to register my company to apply for the loan?
Well,
so I'm filling the form.
I don't know the level of trust you have with that your friend, but you know, if you are filling the form or you want to apply for the loan in the name of the company, definitely they will make payment to the person's account, and it is based on his own company. I don't know what you intend to run, or you two. I don't know whether you are going to ginger production, or I don't know what you want to go into.
Yeah, ginger production.
But registration of company or business name it will take you uh, nothing less than, let's say, a month, max a month, or let's say if there are technical hitches, 1 or 2, let's say 2 months, but maximum. Sometimes self, if not for the recent delays they're experiencing with CAC, registration of company will take you like 3 weeks. You have your company registered and you get your certificate. But due to some problems now, it takes a month and a half, sometimes 2 months. But it's advisable you register your own company. You don't know whether before the loan will come out, you and that friend, you are not in good relationship. So if the money is paid to his account or something, how will you get the money?
Hello?
But if you trust that friend, I don't see reason, and you are considering time, I don't see reason why you can't use the company. But it's advisable if you can just register a business name or register your own company.
It's okay, sir. Despite in the form I feel, I use my own company name. I do not use his own company's name,
Mm.
and my company is not yet registered. I hope I wouldn't have any problem to access that very loan.
Well, I think one of the prerequisites for obtaining the loan is you must have a registered business. Registered business. So you can do well. You can start. You can. If you filling this form for this particular training, I guess is different from you filling making application
For
for
loan.
the for the loan. It's not the same thing. This one is for you fill the form to attend this
Okay.
training, while filling the application. You were taught in this school how to fill the form for the application. So in filling the application, you might decide to use that company, but it's still advisable you use
That was yesterday.
you register your companies. Let's say for instance now you want to borrow money from bank. You cannot use that company to borrow money from for your business. One, because the bank will carry out a search with the CAC to see who are the directors of those companies. Are you a shareholder in the company, your friend's company? Are you a shareholder or are you a
Yes,
director? So if
a
you are
shareholder.
a shareholder,
Yes,
okay, so I guess you can use it. You can use it since you are a shareholder in the company. You can use it,
yes.
but in the fact that you are not a shareholder or director, it's not advisable. But in this case, since you are a shareholder, you can use it. Thank you.
You're welcome, sir.
Okay, any other question? Okay, in the absence of any other question, uh, we've come to uh, end of my class for today's module. So I will hand you over to the project manager for closing remarks. Thank you very much. You're welcome, sir.
Thank you, Barrister. Thank you very much. I appreciate a wonderful lecture this morning. Participants, good afternoon. A pleasure to be with you this afternoon. We have come to the end of the week's lecture, and I hope you all benefited from the series of talk we gave you since the beginning of the week. And we hope that when you start your business, you access the loan, you will be guided by during this training, and we hope that it will be able to help you in managing your business. I want to appreciate all of you for your patience, for being there with us to the end of this series, and hope that this will not be the end of our interactions. We will, of course, be engaging with you further going forward. Yeah. Like I said, I did mention when I had my last class on Thursday, we normally issue our certificates to our participants on Saturdays. That's our graduation. We have some kind of mini graduation. It's an online graduation, nothing physical. We'll just send you some graduation speeches, and after that is done, we send you your certificates. We open the class by 12 noon. At 12 noon, we send the first speeches that we're going to deliver. By 1, we do the final and then the closing. And then, of course, the certificates will follow thereafter. But we like to leave our platform open just in case you have anything that you want to display for exhibition. You want to market amongst your colleagues so that they know and see what you are doing. If under such a circumstance, the platform will be open until next week, Monday, when we'll close the platform for that purpose. But basically, that's the opportunity we provide for members who are already into business, who want to exhibit their things, their products, want to sell their products online, to be able to reach out as much as possible to their colleagues. Finally, when we issue the certificates tomorrow, we'll draw your attention to it that the certificates have been released, and if you have any comments on them, you welcome the comments. Any mistakes, anything that you want us to correct or amend, you let us know so that we attend to it. All right, having said that, let me thank you immensely for sharing the week with us. And then wish you all the very best going forward. And for this day, we wish you the very best of the weekend coming ahead. Thank you very much, and Have a wonderful day ahead of you. Bye-bye.